Hello, I am Professor Shiladitya Rakshit. The Human Rights Committee, this is Module 20, ICCPR, is a body of independent experts that monitors the implementation of the International Covenant of Civil and Political Rights by its state parties. Obliged to submit regular reports to the committee on how the rights are being implemented. It is to be noted that the committee requests usually every 4 years. The committee examines each report and recommendations to state party in the form of A, the concluding observations. Article 41 considers interstate complaints the first optional protocol to the covenant. This protocol gives the committee's competence to examine these individual complaints with regard to alleged violations. So, what are the learning objectives? First, to get an overview of the ICCPR, to understand the relation between ICCPR and the Human Rights Committee, and to understand the various supervisory mechanisms of the ICCPR. Now, having given a brief introduction, let us understand what is the composition of the ICCPR. The Human Rights Committee is composed of 18 independent experts who are persons of high moral character and recognized competence. Their competence in the field of human rights. Members elected for a term of 4 years by states and these state parties in accordance with Articles 28 to 39 of the Covenant. Members serve in their personal capacity and may be re-elected if nominated. The chairperson of the Commission is Mr. Fabian Omar Salvioli from Argentina. He is the chairperson, and the relation between the ICCPR and the Human Rights Committee. Let us understand that ICCPR was adopted by the United Nations General Assembly in Resolution 2200A21 on 16 December 1966, which came into force on 23rd March 1976. As of June 2015, 168 states were party to the Covenant. Article 1 on the right to self-determination, which is identical to Article 1 of ICCPR and Part 2 of the Covenant, contains Articles 2 to 5. These Articles 2 to 5 refer to the nature of obligations, the territorial and personal scope of the Covenant, and the principle of non-discrimination. Article 2, which is complemented by Article 3, guaranteeing the equality between men and women. So, it is away from gender bias. Then what is the relation between the ICCPR and the Human Rights Committee? Article 4 allows states to take measures derogating from their obligations under the Covenant. Article 5 establishes a prohibition of abuse of rights. Article 5, subclause 1, and a saving clause, Article 5, clause 2. Part 3 of the Covenant contains the following substantive rights. They are the right to life, which is Article 6, freedom from torture and inhuman and degrading treatment or punishment, Article 7, freedom from slavery, servitude and forced labor, Article 8, rights to liberty and security of the person, Article 9, rights of detained persons to humane treatment, Article 10, freedom from imprisonment for inability to fulfill a contract. The ICCPR and the Human Rights Committee. Article 11 talks about freedom of movement. Article 12 talks about right of aliens to due process when expelled. This is Article 13. Article 14 talks to right to a fair trial, whereas freedom from retroactive criminal law is enshrined in Article 15. Further, right to recognition as a person before the law is Article 16. Right to privacy is Article 17, and freedom from thought, conscience and religion is Article 18. Freedom of opinion and expression is Article 19. Freedom from war, propaganda and freedom from incitement to racial, religious or national hatred is Article 20. Freedom of assembly is Article 21 and freedom of association is Article 22. Right to protection of the family and the right to marry is also enshrined within the scope. The ICCPR and the Human Rights Committee. Article 23 talks about the right of protection of the child. Article 24 talks about right of participation in public life, which is Article 25. Then there is right to equality before the law and right of non-discrimination, which is Article 26, and rights of minorities, Article 27. There is an optional protocol to the Convention of an individual complaints procedure. This was adopted by the UNGA in Resolution 2200A-21 of 16 December 1966. On 23rd March 1976, as of June 2015, 115 states were party to the optional protocol. The ICCPR and the Human Rights Committee also envisions the second optional protocol to the International Covenant on Civil and Political Rights, aiming at the abolition of the death penalty. This was adopted by the UNGA in Resolution 44/128 on 15 December 1989. On 11 July 1991, as of June 2015, 81 states were party to the second optional protocol. Then you have the various forces and committees to look into the various tasks. One is the Country Report Task Force Committee. The committee has replaced the working group on Article 40 of the Covenant with Country Report Task Forces. The principal purpose of the country task forces is to identify in advance the questions which will constitute the principal focus of the dialogue with the representatives of the reporting state. The Country Report Task Force has between 4 and 6 members. Balanced geographical distribution and other relevant factors are taken into consideration. It is to be noted that one of these members is the country rapporteur. The country report task forces comprise: first, the country rapporteur presents the draft list of issues for discussion to the country report task forces. The list of issues is adopted by the task force as a whole. The task force then allocates to each of its members principal responsibility for a certain number of questions. These questions are included in the list of issues based in part of the areas of particular expertise or interest of the member concerned, and it is transmitted to the state party. So, this is how the operation goes. In 1999, the lists of issues has been adopted at the session prior to the examination of the state report, allowing a period of 2 to 4 months to prepare for the discussion, which was important for with the committee. Then there is an option of constructive dialogue. Rule 68 of its rules of procedure allows it to examine reports in the presence of representatives of the reporting states. The committee has stated that if it is able to perform its functions under Article 40 as effectively as possible, and if the reporting states is to obtain the maximum benefit from the dialogue, it is desirable that the state's representatives should have such status and experience, and most importantly, preferably be in such number. Now, what is the constructive dialogue? If a state party has submitted a report but does not send the delegation to the committee may notify the state party of the alternative date. This alternative date is the date which it intends to consider the report, or may proceed to consider the report at the meeting. This meeting had been initially scheduled. Furthermore, the committee will examine the report and prepare provisional concluding observations, which will be submitted to the state party. The committee will mention in its annual report that these provisional concluding remarks or observations were prepared, but their text will not be published under any circumstances. What is the procedure then for a constructive dialogue? The following procedure is generally used for the examination of state party reports. The state party is invited to introduce the report by making brief introductory comments, followed by the replies to the first group of questions. The state parties are encouraged to use the list of issues to better prepare for a constructive discussion. All committee members participate in this dialogue. The members of this country task force were responsible for a pre-assigned number of such questions. The representatives of the state party is then invited to reply to the remaining questions. Furthermore, on issue of constructive dialogue, the committee devotes 2 meetings. Each meeting is for a span of 3 hours each. In this meeting, the examination of periodic reports to the examination of initial reports. Individual members of the committee maintain the highest standards of impartiality. The final phase of the committee's reports / examinations of the state report is the drafting and adoption of its concluding observations. For this, the country rapporteur prepares, with the assistance of the Secretariat and based on the constructive dialogue held during these plenary sessions, and after that draft concluding observations for consideration of the committee. The agreed structure of the concluding observations is as follows. It talks about introduction, positive aspects, factors and difficulties impeding the implementation of the covenant, principles subject of concern, suggestions and recommendations. Further, a recommendation requesting the wide dissemination of the concluding observations. Paragraphs required requesting the additional information to be provided to the committee. The draft is then discussed by the committee in private session with a view to adopting it by consensus. Follow-up to concluding observations, comments. A follow-up procedure shall be employed. This procedure is employed in order to establish, maintain or restore a dialogue with the state party. The committee shall appoint a special rapporteur, and the function of the rapporteur is basically will report this to the committee. The special rapporteur takes steps to meet the recommendations of the committee. The sessional follow-up progress report will prompt the committee plenary to make a determination of the date, deadline for the submission of the next report. This follow-up procedure does not apply in cases of examination of country situation. Now, what are the strategies to encourage reporting by state parties? The committee has noted that only a small number of states have submitted their reports, and these are timely submissions, submitted with delays ranging from a few months to several years, and some states still parties are in a state of perpetual default. State parties is the fundamental mechanism, and the committee discharges fully its obligation to monitor the observance of obligations under the convention. The state party has not presented a report. The committee may at its discretion notify the state party of the date on which the committee proposes. It also examines the measures taken by the state parties to implement the rights guaranteed, and these rights which are guaranteed are always under the covenant. The state party is represented by a delegation. The committee will, in presence of the delegation and in public session, proceed with the examination. This examination is on the very date assigned. If a state party is not represented, the committee may either decide to proceed to consider the measures taken by the state party to implement the guarantees. These guarantees are those which are enshrined of the covenant at the initial date or notify a new date to the state party. Interaction with specialized agencies and bodies of the United Nations. The committee invites specialized agencies to provide written reports. These written reports contain country-specific information on state parties whose reports are before them. Representatives of these entities are also invited to address the committee at the beginning of each session. Furthermore, the United Nations Secretary General can, after consultation with the committee, do a specific task, i.e., transmit to specialized agencies parts of the reports received from state parties, and specialized agencies then may submit comments. Participation of non-governmental organizations and national human rights institutions in the committee's considerations are taken into account. Now, as far as these institutions are concerned, the committee invites non-governmental organizations and national human rights institutions. The committee sets aside the first morning meeting of each plenary session. These plenary sessions and the morning meetings is to enable representatives of non-governmental organizations to provide oral information. Interstate complaint procedures are also there under the ICCPR Articles 41 to 43. The state party shall first bring the matter to the attention of the other state party. That is the first step. And the other state party must be a concerned party. The receiving state shall within 3 months provide the sending state with an explanation or a statement. Both the explanation and statement must be in a way to clarify the matter. If the matter is not adjusted to the satisfaction of the states concerned within 6 months, either state may refer the matter to the committee. If satisfied that all available domestic remedies have been invoked and exhausted, the committee shall examine the matter and may call on the states concerned to supply any relevant information. Then there is an interstate complaint procedure, which is ICCPR Articles 41 to 43. The committee shall within 12 months submit a report confined to a brief statement of the facts. The good offices of the Conciliation Commission shall be made available to the states concerned with a view to an amicable resolution of the matter, or rather amicable settlement of the matter. Like previously, if no amicable settlement has been reached, its finding on all questions of fact relevant to the issue and its views on the possibilities of an amicable solution. The parties which shall within 3 months indicate whether they accept the contents of this report or not. It is to be kept in mind that there is also an individual complaints mechanism, which is the first optional protocol. The committee deals with communications it receives at a precessional working group on communications which meets prior to each of the committee's sessions. This working group is entrusted with the task of making recommendations to the committee. The recommendations are regarding communications received under the optional protocol. The committee may designate special rapporteurs and the working group by assisting in research, and not only research, but drafting a requisite number of recommendations. These drafting of requisite number of recommendations are basically on complaints ready for action, normally 25 to 30 per session. Then you have the individual complaints mechanism, the first optional protocol. The committee allocates time at each of the sessions to examine the communications. These communications are those that are received as well as recommendation made by the pre-sessional working group on communications. The committee considers these communications at private meetings, and all documents related to the communications remain confidential. After examination, the committee shall forward its views to the states and the individual. It is to be kept in mind that only the final decision on any given complaint, that is the inadmissible decision or decision on the merit, becomes a public document. Individual complaints mechanism, for example, which is the first optional protocol, talks about individual members of the committee who refrain from participating in any aspect of the consideration of the communications, provided the state of which they are nationals is a party to the case, or if the member has any personal interest in the case. If the member has participated in any capacity in the making of any decision on the case covered by the aforementioned communications. To this, the special rapporteur shall make recommendations for further action by the committee. As necessary, the special rapporteur shall regularly report. Thus, to summarize, the module's aim is basically to interpret the covenant so that there can be no doubt about the scope and meaning of its articles. Further, these articles have become an important functioning of the committee. General comments are normally directed at states, parties, and usually elaborate the committee's view. This view is on the content of the obligations of states, parties to the covenant. Thank you.